Your medical records will win or lose you your case. Here are 3 principles to turn them into a weapon. It's Greg Klote here from Halvorsen Klote Davis. In a personal injury case, your medical records are the case, not testimony, not other things, the medical records. AI reviews them word for word. Adjusters and defense attorneys highlight them line by line. They are the most important thing in your case. And I'm going to tell you today how to make them work for you, not against you. There are 3 big principles to medical records, and here's principle 1. Every visit, every symptom. And here's what I mean. If you go to the ER, urgent care, physical therapy, orthopedic, chiropractor, every visit you need to tell them everything that you're feeling, everything that's going on with your body, with your health, okay? If you go in there and your neck and back is hurting, don't just tell them what's hurting the most. You know, my neck doesn't really hurt as much as my back, so I'm only going to talk about my back, okay? You need to tell them everything that's going on. If you're having numbness, if you're having headaches, pain, tingling, all those symptoms. And here's why. Because if you don't do that, then 6 months down the road, when the adjuster comes back and says, you know, they didn't mention their back, so there's no way that they could have back pain. And maybe it just was some oversight, you know, by the client. They wanted to focus on the neck, or they wanted to focus on their leg or their arm, and they forgot to mention it, but it was hurting. It will come back at the end to haunt you. Principle 2, stay consistent. When you go to the doctor, don't tell them, you know, one visit that your pain is a 1 out of 10 and the next visit it's a 10 out of 10, right? Be consistent with your pain. Be honest with them. Tell them exactly how you are feeling, okay? Don't over-exaggerate, just be honest. Make sure that you're telling them exactly what is going on. Principle 3, follow the plan. If your doctor tells you to come back in 2 weeks, come back in 2 weeks. If your doctor refers you to a specialist, go to the specialist. If you're at physical therapy and your doctor's ordered physical therapy 3 times a week, go 3 times a week. You have to follow the plan so that way when the adjusters look at the records, defense attorneys, it shows that you were compliant and you did everything you could to get better. Now, what are things adjusters look for? Well, here are 3 big ones, okay? The first one is the gap in treatment. We've talked about this before. 30 days is considered a gap in treatment, or going longer than the doctor recommended. 60 days, they consider that a red flag. Make sure that you're going to the appointments that are scheduled and make sure that you're following up consistently. 2, discharge. Meaning when a doctor puts you at maximum medical improvement, and sometimes people say, well, I'm going to go get some more treatment, or they stop treatment before they get to maximum medical improvement. This discharge issue really comes up whenever they're reviewing it. They'll say, well, why did they get more treatment if the doctor said they were as good as they could get? Or they'll say, well, why didn't they finish their treatment course? And the last thing is inconsistencies. If you're being inconsistent and didn't mention something at one point, but 6 months later you're mentioning injuries, or you weren't consistent with your treatment, these are the things that adjusters are looking for. And they're looking for these things to devalue your case. This is what they're combing the records for, so they can come back and tell you these things. So here's the couple do's and don'ts of what you need to do when you're talking to your doctors to go in the records, right? Do be specific about issues. I couldn't sleep last night. I got up at 3 a.m. I've been waking up frequently because of the pain. Unable to lift my child and hold them, you know, because my shoulder hurts so bad. The specifics matter and they're important. Another item you can do is talk about how it affects your daily life. Like we mentioned, things where we can relate it back to our daily lives rather than just say I'm in pain. Say the things that you can't do. I can't do the dishes. I can't carry in the groceries. I'm unable to carry the laundry up flights of stairs now. I can't help myself in the shower. Whatever it may be, talk to them about how it's affecting your daily life. These translate later on in the case, and these are value drivers to a jury. Couple don'ts. Don't exaggerate. Don't say your pain is a 12 out of 10. People smell this and think that they can't trust you. Just be honest. If the pain score is 10 out of 10, then 10 is the highest score you can give. Don't minimize things. Don't say, well, my neck's feeling better, or I'm not going to mention it because really my back. Tell them exactly what's going on and be honest about every single injury you have or lingering symptom. Don't minimize them. Last thing is don't discuss the case or settlement or anything like that with your medical providers. That's not their job. Their job is to treat your injuries and get you better. You do not need to discuss any aspects of your case with them about potential values or liability or anything. You can tell them you've been in an accident, that you were injured, of course, but that's to the extent you need to talk to them about it. Don't talk to them about any other detail of your case. Now remember, throughout your treatment, your attorney should be requesting your medical records and bills, and they're going to be reviewing them throughout your treatment plan. Now, if you've had a few visits already and you're nervous, don't be. Almost every medical record has something going on with it where a client didn't exactly say that or a provider forgot to put something down. We deal with this all the time. Be honest with your providers, follow the plan, do the steps that are necessary. Remember, accidents happen, we can help. Halvorsen Klote Davis.